chapter president for ACEDS. This is actually our first panel event, so you guys are our test audience. So thanks for coming out tonight. Before we get started, I just wanted to give a little history on ACEDS for those of you who aren't overly familiar. ACEDS is a 1,500 member association, mostly U.S. It's also in 15 other countries. Really, the primary, the core focus is to increase e-discovery confidence within the community, whether it's attorneys or paralegals, litigation support, service providers, e-discovery practitioners, whatnot. And one of the main ways we accomplish this is through education, training, networking, like we're doing tonight and after the panel, and certification. As many of you know, ACEDS offers the CEDS credential. Currently, it's held by over 1,000 practitioners around the world. A few of whom are in the room tonight. A few of the more prominent names in the legal community who have CEDS professionals among their staff: Baker Hostetler, Hogan Lovells, Greenberg, Traurig, Stroop, companies we all know like Apple, Google, Walmart, Ford Motor Company, and some government agencies, Department of Justice, the SEC, and the FCC. It's a certification that's been gaining a lot of traction and respect among the industry and also major clients. So, before I kick it off to the experts here, I just wanted to, mention one thing regarding membership of our chapter. We're looking to do 4 to 5 events like this per year, give or take 1 a quarter, as well as members-only webinars. We have some podcasts underway, and so it's not, all work. Typically, maybe like a social, like a happy hour once or twice a year. We're also offering a 15% discount on membership for the next 3 days. If you're interested in signing up within the next couple of days, I can give you a discount code to go online. I'd like to kind of pass it off to Joe Bartolo, who will introduce our moderator and Pat. Thanks, Joe.
Hello, New York. Thank you all for coming tonight. I really appreciate it. Thank you to all of our esteemed panelists. I think this is going to be a great event. It's certainly an issue that is one of great concern to the legal profession right now, so I'm certainly looking forward to hearing the insight from our subject matter expert panelists. I'd like to thank Joe Alonzo, the chapter president, as well as the other board members for the Metro New York chapter board for ACEDS for participating in this. I also want to thank Brad Chappell, who couldn't be with us tonight, who's my co-chair of the educational committee for ACEDS. And with that, we're going to kick off the event. We have Christ Costello. He's our moderator here from Winston Strawn. He's their e-discovery counsel. He's filling in for Scott Cohen, who's on the global advisory board for ACEDS, who's also a member of this firm, who's with this firm here at Winston Strawn. Again, thank you all for coming out tonight for tonight's cybersecurity and legal profession event. And I'd also like to thank Litigation Video Technology for recording this event for us. With that said, if there's questions during the event, feel free to raise the questions. We have a slide deck that we're using to assist with the panel discussion tonight. We're going to be skipping through some of those slides, but the slides will be made available either through download from the ACEDS website, or we can certainly email you the slide deck as reference material if you want the slide deck after the panel discussion tonight. Thank you all again.
Thanks, Joe.
Thanks.
Chris?
Thanks, Joe. So just before we get started, there's a couple ground rules. If you want to say something, feel free. That's the only ground rule. You're allowed. There's a couple microphones that'll run around and throughout. All the panelists like to have a really free-flowing discussion, although we'll set it up and I'll ask them questions and they'll respond. Part of this is to engage you guys in the process, so feel free to ask your questions. And if we get a little over time, Joe will be, making some motions on the side and moving the slides, and we'll just sort of move right on through as we go forward. So thank you all for coming. And now I will actually introduce the rest of the panel so that it's not a secret who these guys are. I'll start with Gary, who's here over here. Gary's a partner in digital media technology in the privacy groups at Davis Gilbert. He regularly counsels clients with respect to privacy and data security, new media, advertising law, and information technology matters. He is a certified information privacy professional and co-chairs the International Association of Privacy Professionals New York City Knowledge Net Group. Thanks, Gary.
Thank you.
Sitting next to Gary is Dr. Chase Cunningham, who is the threat intelligence lead for Firehost, and he proactively seeks out cyber threat tactics and technical indicators of various threat groups. He is regularly cited as an expert on cybersecurity and contributes to white papers and other publications. He's also the co-author of the, I'll have to pronounce it correctly, but CINJA, there we go, a comic designed to educate children about security threats and online best practices. And sitting to my right is Dana Post, and she serves as special counsel, e-discovery, and data management at Freshfields, Brookhouse Derringer in New York. She's a member of the firm's cybersecurity practice and counsels clients on cybersecurity preparedness and data breach litigation strategy. So welcome to all three of you. Thanks for coming. Thanks for coming to Winston. Thank you, all of you, for coming. I'm here every day, so this is really just sort of at home for me, but I understand, and thank you for coming. So the first slide, did we skip ahead, Joe, or are we? Okay, all right. So basically, it's not a secret to everybody in this room that cybersecurity is a major concern for not only us, but our clients and people in the industry, basically everyone, right? Whether you want to admit it or not, it's a major topic. And so there are, as we look at this, you skip back on me, 8 major concerns. But we can, why don't we go to that one while we're there? Yep. The 8 topics. Anyway, all right. As you can see, this is a little bit of a work in progress, but we're getting there. We're getting there. All right.
I'll go back to the other slide.
That's fine. So, really, what we're looking at here is we all kind of understand that law firms handle a lot of data, right? They handle trade secrets. They're handling a lot of corporate information, personal data, healthcare information. All of that information is now stuck in the law firm, but are they really secure enough to hold that information and protect their clients' data? And that's where we're coming into, really, are they going to be the subject of cyber attack threats? And the answer is they are. And that's what the next question is, right? What is the standard that law firms are going to operate under? And really, it's that they're going to have a reasonable security for information that's held. Now, we have lots of standards in the legal profession, but what does reasonable security mean? It's not really well defined, right? So there's no single security checklist for all of this. There's not like a playbook that we can turn to say, hey, these are all the things that you as a law firm can do to protect your client's data. And so therefore, what are some firms doing and what are their concerns, right? So here we're now back to those 8 major cybersecurity concerns. One is that we're not taking a strategic approach to cybersecurity spending, right? I mean, these are all sort of self-explanatory, but when you look at them and each one of them, it's law firms are not taking the time to say, okay, how am I protecting my own data and my client's data from the standpoint of allocating enough resources, investing in the technology? Again, leading to the next point, which is we're not addressing those concerns, those capabilities. We're not putting together an analysis of the supply chain risk. We're not addressing security for mobile devices. Now, I will admit that I'm one of those people that really did not like to have 2-factor authentication on my BlackBerry. I don't like to have to put in my little code just to open up my messages. I'm a recent iPhone user, so now I can use my thumb, which is nice. But there are plenty of us out there that are a risk because we have devices that will be left around. We're not, as a profession, addressing those risks adequately, right? Individual firms are, but as a profession, we are really leaving this open. We don't collaborate enough amongst ourselves. Right? And these are all generalizations. Some firms are doing a better job than others, but we're all in this together. And so whether I want my opponent to have good security or not, I think we all should. Right? If they want to lose something and help my case, that's great, but I'd actually rather that everyone protect the data. We're not addressing the insider threats. And insider threats can be a malicious employee. It can be that person that leaves their data hanging around when they shouldn't. It could be the guy that leaves the computer at the airport, leaves something open when he shouldn't, going back to the old-fashioned, it's leaves the papers in the conference room and have somebody else come in and look at them, right? But it's the same concept. And then we're not looking at how we're going to provide enough training to our employees to address those risks. So those are the concerns that are out there that are motivating what's happening, which leads to the question, which we're looking at here, is really, are we losing that cybersecurity war, right? So 79% in this Marsh survey, 79% of the respondents viewed cyber privacy security as one of their top 10 risks. 72% said the firm has not assessed or scaled the cost of a data breach based on the information it retains. 51% said that the law firms either have not taken measures to ensure their cyber risk or do not know what they've done. And another 62% haven't calculated the effective revenue lost or extra expenses. Right now, while the numbers would change, but these are obviously concerns for not only the law firms but for businesses as well. And the next slide, you're looking at, what is really happening here. You're seeing a lot of CEOs become more concerned about cybersecurity year over year. You're going to have people report a security incident. I can honestly say I just got letters in the mail saying that Blue Cross Blue Shield, through their Anthem subsidiary, had a data breach. When I called them for something else, they said, if you want to talk about the Anthem security incident, press 1. If you want to talk about another one, press 2. Right? So this is happening more and more frequently. In fact, they're saying about 135 average cyber incidents per corporation on average in 2014. Right? And again, there's varying levels of what constitutes a cyber incident. So 69% of those corporations that report an incident are unable to estimate the cost. So really, this is becoming a major problem. And that leads to what's on this slide, which is where are we going to see spending? Where are GCs seeing their spending in 2014? But you could apply this now, right? You've got information governance, you've got data security, data privacy, and e-discovery. All of those are, you're going to say they're roughly in the same ballpark, but I would say that you're going to see the data security side increase continuously. The e-discovery side, if we're all doing a really good job advising our clients, that number is going to come down, right? But the data security and the info government is just going to keep expanding, so that pie is going to be changing. So you guys have probably heard enough of me talking, but I would like to, and the rest of these slides will be here, but, we've got firms that are on top of it. And I have to say, yes, I do work at Winston, and yes, we are in the process of getting ISO certified, but there are other firms that are already ISO certified, firms like mine that are working towards that. But that's a big step, right? It's a process that you have to go through, and not every firm is going to be in a position to be able to do that. And so that's one thing that we're keeping in mind throughout the whole process. So that's going to lead us to the questions for today, really, which is, what methods are available to reduce the risk of a breach? And are there industry standards and best practices for cybersecurity? And if so, what are they? And I'd like to turn this over to Dr. Chase Cunningham to start addressing, and then we'll kind of move through this and the rest of the slide deck.
Thanks. I think the first thing, really, methods as far as reducing your risk is to actually know what's going on in your network. Most people, when you go talk to their IT group or whoever's running their IT infrastructure and you actually say, tell me what's going on in your network. Let me know what the baseline is. How much have you changed in the last 12 months? They sort of give you a look like, well, yeah, that's something I should be able to tell you, but they can't, right? We live in this environment right now that is absolutely incredibly dynamic. I mean, if you think about how much stuff has changed in the last 3 years, let alone the last 5, we're totally polar change in things. You move to cloud, you move to whatever, you bring in BYOD, you start throwing, everybody's on Wi-Fi right now. Nobody has to worry about the internet access at all times. How hard is it for someone to actually control what's going on in their enterprise? It's almost an inevitability that there will be something that gets away. I've been on lots of pen tests, lots of red team exercises and things like that, and I have yet to find an organization that has been from day one, this is my network, this is my enterprise, these are my assets, and this is how everything is connected, and I own all of that infrastructure. Most of the time it's, well, we've got networks and we have some of this over here, and I think we just put that piece into this, and this new technology is going to solve all of our problems, but it doesn't really do that. The first and most immediate way that you could really sort of take that first step to reduce that level of risk is absolutely know everything that's going on within your enterprise and your network. If you can't do that, you're trying to climb a hill that's frozen with ice skates on. You're never going to reach the top. Do you want to go?
Yeah, I can go ahead and jump into that. Being the lawyer, we love policies. Policies are great. Policies for this and that. But it's always important to make sure that your policies match up with reality. Because, oftentimes I'll have a client call me up and say, can you give me a policy for whatever? Because they want to check the box that they have a particular policy. But, a policy should be very specific to your environment. So, on this page here, I talk, probably the global term is information security policy, a policy that addresses what information you store and how you keep it secure. And, that's incredibly specific to your environment. It's not possible to follow someone else's. And going to one of the points earlier that was mentioned about sort of an inventory of your systems and what you have, it's hard to decide how to protect your network and protect your information if you don't understand what you have in the first place. So you need to understand what is in your environment, and then you start to build a framework around that. Chase had mentioned BYOD, bring your own device. That's a big concern in all industries, not just law firms, about what devices people are using. Do you have the ability to secure the information on that device? Do you have the ability to remotely wipe the device if it's lost? Is there a policy for employees to tell them what to do? For instance, one of the most important things is if they lose their device, to tell IT. Don't keep it a secret and don't wait. And so it's important to explain to people that if you want to use your own device, we're going to have certain ground rules. I talked there about vendor policies. We'll talk about this a lot in terms of risks to any organization, including the law firm. Chris had mentioned the insider threat, the employee threat. That's probably number one. And number two is the vendor that you didn't think had access to information or you trusted without doing a proper review of their controls. And then the other three policies I have up there are important policies to have when something goes wrong, because you need to look at security incidents not as an if but a when. It will happen. There will be some issue. It may not be catastrophic, but there will be some issue you have to deal with. So I talk about a security breach incident response plan. And that really is the framework about what you're going to do, starting with that first minute that somebody reports a security incident. Who gets involved in your team and who's taking control of it? Because you don't want everyone running around like chickens with their heads cut off. You want to have some control. You need someone to have control of that organization from IT, from legal, maybe from HR, depending upon the type of breach you're dealing with, and someone who's capable of making decisions and there's a plan already drawn out. A lot of folks will draft up one of these plans and then have a mock breach. Act the breach out and make sure that it can be enacted. You might find gaps in your policy. Maybe your policy says that if a breach occurs, you're supposed to notify the following person. Well, what if that person's on vacation? There needs to be a backup. There needs to be a plan. Disaster recovery plan, if you should lose your data, how do you get the organization back up and running? And that's a combination, again, of policies and the reality in terms of your technology. And it kind of overlaps with a business continuity plan about how do you continue to carry on business in the ordinary course. And the clients of law firms are dealing with these issues all the time in their organizations and with their clients. And they are starting to ask those questions of law firms more because they realize, wow, my law firm is an important vendor to my organization. And going to the point of why are law firms targets, I don't know if it was Dillinger or whatever said, why do you rob banks? That's where the money is. So everyone knows there's information in these law firms, and if the banks are doing a great job securing their data, well, there's valuable data over at the law firm too. So let's go look at it in that environment. So I'll say focus on the reality of the technology and focus on the policies and make sure that they match up with one another. And last thing I'll say on that point is that you review it every year. You can't put a policy in place and say, I'm done. Guarantee you, 2 years from now, 6 months from now, your environment's going to change. And your policies need to adapt and change with the technology.
And the only thing I'll add to that is, although we read about all these high-profile hackavits coming into Sony and Target, the most likely cause of a breach will be internally from either negligence of an employee or intentional conduct of a disgruntled employee. So really important to have trainings in place to don't click on suspicious emails and don't use personal, sorry, Hillary, but don't use personal email for work. and just don't use thumb drives. It's very important to have those policies and to enforce them. So that way, if someone leaves their laptop in a car, that really there's no data to be had by the person who finds that. Mm-hmm.
Okay. So then, now we've talked about what are the threats. Now what do we do? What do we do when a breach happens, right? What needs to happen after a breach has occurred? And Gary was talking about this a little bit, so we'll continue on. I'll start with him. But the other question is, are there different legal obligations for law firms after a breach than for a corporation? Right? There are notification requirements in many states that require corporations to send out these notifications. Do the same notification laws apply to law firms? Those are questions that we would be asking. So Gary, you want to handle this one? Start off?
Sure. And I'll kind of maybe bounce around a little bit here. Let's see where we are right now. So on the planning side, we talked about that incident response plan. You've got to know what to do the minute the breach comes in. Employees should know who to notify within the organization, and when that notification comes in, there should be a group that's activated right away in all the different functional areas and appropriate backups, and they know what they're supposed to do. And again, great idea to actually test that plan so that you can do a mock breach and see if it works. See if if you can address things right away. Let's go over to the next slide. So in terms of activating the plan, chain of command is very important. I go to the fourth bullet point there about involving counsel. When I work with corporate clients, one of the big things we always say is when there's a breach, in addition to getting your IT folks involved right away, you got to get counsel involved right away, because you may want to keep things privileged about this matter. And a lot of times when there's a breach, my clients have me hire the outside forensics companies because they want to have those companies under attorney-client privilege, and so they want me to engage them and then have everything privileged there. You will want to engage forensics folks. You want to be careful that, and Chase can probably talk even more about, damaging the chain of evidence. If something has happened, you want to figure out what's happened, but if somebody goes right into the server and starts messing around with things and ruining it, then you may destroy evidence of an attack when you needed a proper forensics company to look at the system and analyze what happened and gather those breadcrumbs to figure out what occurred. And at the end there I say, law, contracts, PR, best practices. You've got a number of obligations. Of course, there are legal obligations about security breach notification, which we'll talk about in a moment. Then you may have contractual obligations. In the legal profession, we have ethical obligations. But then there's also public relations concerns and best practices. The very unique thing about the law firm world is you have the attorney-client privilege issue, and we'll talk about security breach notification laws, where there are laws that require you to notify people about a breach. I haven't done a deep dive of it, but I've not seen any enforcement action or case kind of pitting those requirements against attorney-client privilege obligations, because that would be an interesting battle if someone were to say, well, I have information about a particular individual and there's been a breach, but I can't tell that person until my client says it's okay, because that would violate my attorney-client privilege. So I don't know if you've come across that yet.
I haven't seen it yet, but it will have to be coming, because we're all going to get targeted. But one of the questions I had was, as a lawyer, right? So when something happens, and I'm in a unique position here at Winston that I work with the e-discovery guys and the IT guys on a regular basis. But I can understand in most cases where this is going to happen to a firm, it's going to come to someone and they're going to go, I have no idea what to do. Right? And the IT guy needs to go take care of it. Figure out what happened, right? So you're going to say, figure out what happened to your IT folks. That, I think, is a probably even greater problem for the law firm than it might be, because of what we do every day, right? Because we're not trained to be thinking about, I need to hire counsel, or I need to get somebody involved to look at that, right? As opposed to say, you IT go figure it out, and let's get it fixed. So have you seen that? Any of you guys seen that with what you've come across?
Well, from our side, it's interesting that you bring that up, because a lot of what we try and tell people is that if you look at how bad guys actually go after networks and when they cause breaches and things like that, they don't go after 100% of your network, right? When I'm doing pen tests and red teams and things like that in the past, I'm not going after your company's infrastructure. I'm going after your database. So that 1% of your infrastructure, that's what I want. I use the rest of that to pivot my way around until I get to that asset. So you have these instances where people try and secure everything across all that space, which you can't possibly do, and you can't keep up with it. So why not take that 1 or 2%, your real crown jewels, the stuff that you know the bad guys would be coming for, and put that in a vault. Make that where that is just as close to impossible that person or individual or group or hacktivist or whatever else could get to that. And then that's much easier for you to remediate, to fix, to put people on technically, to get that stuff up and running, whatever you need to do with it, than trying to figure out across an ocean of assets what happened and how you technically respond to it and things like that. The groups that I've seen that have done a better job of isolating that really important, really valuable stuff when the things do happen, usually it's much easier for them to respond and do it correctly with a minimal amount of pain than those guys who just sort of say, oh God, they're here, like, now what do I do? And then all of a sudden it's herding cats across space. That works really, really well. And that's honestly, I wish a lot more people would adopt that sort of stance. You can't secure everything all the time, but you can dang sure lock down a vault most of the time.
Good. I should have mentioned one thing at the beginning. It's the standard disclaimer that we always have when we do all these things, that what we're expressing up here is our own beliefs and not necessarily those of our firms, and so that would be, just the standard disclaimer.
Yep.
Since we're talking about law firm world, I thought I could throw that in.
Hop over to the next slide. I can talk to you a little bit about the way state security breach notification laws work in the U.S. And I know a lot of times in law firms we kind of view ourselves as not in the real world. But if we were at a real company, these are the types of things we'd be concerned about. So this all started back in 2003. And before I became a lawyer, I was an IT guy. And the idea that if there was a security incident that we would have to actually go out and tell people was like insane to me when I worked as an IT guy in the early 90s. Basically when there was any type of security incident, we'd sit in a room, we'd whiteboard it and figure out how to solve it, and whoever was in charge would then point their finger around and say, all right, now don't tell anybody what happened. So then California comes around in 2003 and says, hey, wouldn't it be nice if when companies suffer a security incident, they actually told the data subjects whose information was exposed. So that was just a radical 180. And the law, some people noticed it right away and it kind of sat there, but then it took a while. But now 47 states have state security breach notification laws, which in a nutshell say that they're all very different. In 47 different laws, they don't all match up, which is great for folks like me and Dana. It keeps us very busy. We have a lifetime guaranteed employment here trying to interpret this stuff. But in general, the laws say that if you have unauthorized access of unencrypted personal information, you then need to notify the data subject. Now, there's a million wrinkles to that. Firstly, what is personal information? Each state defines it differently. Is it unauthorized access or reasonably suspected unauthorized access? There's variation between the states. Some states have a risk of harm approach. There could be unauthorized access, but you determine there's no real risk of harm of identity theft to the individual, so you don't have a notification obligation. Some states have a requirement to tell the state attorney general. So there's a lot of different things there. So, again, in the real world, this is what corporations are dealing with right away, that they know when they have a breach, they're going to have to tell somebody based on these laws, and they're going to have to analyze the situation. And usually the first thing we start to analyze is, what data has been exposed. Did it meet the definition of personal information? What states are those individuals resident in, so I can analyze those states and come up with the approach. And in a lot of client contracts, there's a specific obligation to notify clients within a particular period of time as well. Now, you see the last bullet point there. It says it generally applies to unencrypted personal information. So, for those who are not so tech savvy, you might say, all right, well, why not just encrypt everything and then everything is solved? And Chase will probably tell you, it's like, go to your IT people and say, can you encrypt everything in the organization?
Yes.
And they'll say, sure. Triple my budget, quadruple my staff, and we'll have it done in 2 years.
Yeah, it's just a matter of money. Yeah.
Yeah, it's like it can be done. It's just it's not getting done with the budget and resources you give me right now. So some things can be encrypted, but the reality is everything is not encrypted. So we just have to deal with that reality.
Well, and I think when you start looking about the timing of reporting on these types of things, that's a real problem too, right? Because you keep hearing in the news how they've known about this breach for X number of how long, and then they sort of let it out of the bag that, oh, we got breached 6 months ago. Well, the reality of that is a lot of those enterprises and organizations are so vast and so large, and they have so much to control. If you talk about Target, like Target had actually just spent a few $1 million on a very powerful system right before they got hit, and it was actually notifying them that something was going on in their network, and they got sort of like fed up with it, and they turned it off. And then they had to notify everybody that they got breached, right? So they were doing the right things except for turning off the alarm. And then they had to go back and say, well, we got breached. Well, luckily, because of that system that they had just spent millions of dollars on, they could go back and at least tell you the day that occurred, which was 3 months ago. But most organizations, unless they have a really well put together security operations center and they've got a good baseline going, they might not know that they're breached for 6, 9, 12, 18 months. There's been some where it's been up to 40 months before they even knew that they had a breach occur.
Right.
I mean, that's 4 years.
That actually goes to the point that an IT person may just patch it all up, right? Whereas the better thing to do is sometimes not patch it up because there's holes. They've been in the system. They know how to get in another way, and to study what they're doing and discover the source of the breach.
And the timing works everywhere in terms of the legal requirement to notify. In the state security breach notification laws, most of them don't have a specific timing requirement to notify. They say you notify in the period of time that's most expedient, given the circumstances. But I think there are a few states now that have either a 60-day notification or even 45-day notification. I think one of the federal bills that was proposed on a federal standard wanted to have notification in 24 hours, which is it's impossible. I mean, within 24 hours of breach, you don't even know what's happened yet. I mean, it takes time to figure out, to analyze. And then you have clients, in their client contracts with other parties, again, the other party may say, we want you to notify us within X number of hours within a breach. Again, if a breach happens, you're not going to stop analyzing it to start calling people right away. You're going to start to activate your team, get people together, and it's going to take, 2 days, minimum before you really know what's going on. And then there's, just the practical, reality. If you played out a breach. All right, it's 1 p.m. Someone called in and said there was a breach. All right, I'm going to call the guy who's, in charge of our IT who would handle it. He's in a meeting right now. All right, he calls me back 20 minutes later. And then he says, oh, I need to get my other guy on my team. And he's out at lunch. He comes back in an hour. It takes a little time to get people together and to analyze what happens. So there has to be realistic expectations in terms of the amount of time. You have to move quickly. But, any of these requirements that you have to notify someone within an hour of a breach or notification to consumers within 24 hours, it's completely impossible. It takes time. The reverse is don't take forever. I think the Connecticut State Attorney General has brought an enforcement action against a healthcare provider because they felt the amount of time that they took to notify consumers was too long, and their state does not have a specific period of time. But I think they notified within 90 days, and they felt that was too long. You should have been able to move faster than that. So you got to find the right balance. Is this more me?
I'm not the lawyer.
Okay. The other thing just to add is that there will be, at some point, a federal law that I think is going to preempt all of these 47 different state laws. There's been many draft discussions. The administration has been pushing for it. So eventually that will happen. We just don't know when. So for now, we have to deal with this hodgepodge of different state laws.
Yeah, so that slide back there, Joe, I can talk about that for a minute. So that was from an ethical opinion from the New York State Bar Association. Going back to one of the very first things that was said about, you're supposed to have reasonable security. What is reasonable security? And that's not defined anywhere. There's actually a very major lawsuit, in the privacy space, and Dana probably knows about Wyndham, where the whole lawsuit is Wyndham versus the Federal Trade Commission, because the Federal Trade Commission sued them over a breach, saying you did not have reasonable security. And Wyndham says, well, what's reasonable security? You haven't defined what's reasonable security, so how can you say we violated the law by not having reasonable security if you don't tell us what reasonable security is? And the Federal Trade Commission, which is sort of our de facto privacy regulatory authority in the U.S., has basically said reasonable security, you can deem that from the size and complexity and scope of an organization. You can look at our prior enforcement actions and see what practices were not reasonable. You can look at our guidance in our reports that we've put out and see what's not reasonable. But in terms of what's reasonable security, depends upon the party, depends upon the circumstance. So this ethical opinion was about a specific situation about with lawyers who share offices and what type of security you have to have in place. And it's going to always be that lawyer weasel word. It's going to be reasonable, and reasonable is going to depend upon your organization. If you are a multinational law firm with 3,000 lawyers and 15 offices, and deal with a certain type of client, you may be expected to have a different type of security than a single office law firm, maybe with only a handful of attorneys. So there's going to be a difference in how you approach it.
One question I'd ask you guys is: are you seeing that your clients are requiring firms to have certain levels of security?
So this is all going to stay within this room, right? Even the camera. Clients are asking. I'm surprised they're not asking more. They are asking, and the savvy clients do ask the question. But I'm shocked it hasn't been more, and I think more will be coming.
I actually have noticed in the past year and a half that questionnaires to be retained as a law firm are much more detailed on our data security systems and preservation of data. So I think it's definitely coming. And one potential client asked if we carry cybersecurity insurance as well. So it's definitely I think going to get more intense.
Well, I think around a lot of that too, from the technical aspect, and this is something that I've said in a lot of things, is that compliance does not equal security, right? Mm-hmm. Compliance is a great thing, and I applaud everybody that strives to be compliant, whether it's ISO, HIPAA, high trust, name the scribble-scrabble of letters you put together to be compliant. That's great, but compliance does not equal secure, especially in the cyberspace, right? In cyberspace, really, the moment that you connect to the internet, you're no longer in your protected environment anymore. You're ISO certified, you're HIPAA, high trust certified, whatever. You have taken your certified organization and connected it to a living battle environment, whether you realize it or not. In a combat space, certifications don't really work. You may have the best stuff that you've done, the checklists that have gone through and everything else. Those guys that are out there that are trying to find ways to do different things to get access to information, they don't play by compliance rules. They go 24/7, 365 to get around that stuff to find ways to get in. So while you may be compliant and you've done the right things and it's absolutely critical, that does not equal security. And I think that that's a common misconception a lot of folks have is, well, I was compliant. I mean, go look at the list from the last year, right? Last year was the year of over 1 billion records stolen. Go look at how many companies were compliant at the time that they got hit. And I think you'll find that it's a pretty staggering number of folks that were compliant on probably more than one level of compliance that got just pulled apart because of this stuff. It's a great thing to have, and it's a necessity, but compliance is not security. Compliance is a piece of security.
Can I just ask you, you're the moderator, I have a question about that, because if there's no standard, there's no NIST framework, what are you complying with, and how do you know what
It's a step, right? So compliance is a piece of an overall security posture. If you're going to do security right, and anyone that tells you that they can do security from here till the end of eternity and never have a problem, they're blowing smoke. I mean, everything happens somewhere along the scale, and no one can be 100% of the time. It's the level of damage that you occur from something happening, right? Mm-hmm. If you're compliant, whether you're high trust, HIPAA, whatever, and you're not, worried about insider threat, or you didn't take care of this, or you don't have two-factor authentication, or you've missed something that should have been plugged into that compliance standard, you're not actually secure. You're compliant. If you really want to get down to it, you need to back out from the overall paradigm of trying to secure stuff from the outside in and secure from the inside out. If you think about it like a castle, most folks try and build their networks and be compliant by building a castle with a moat and a drawbridge, and that keeps everybody inside nice and safe. If you do it the other way, where you make sure that every individual and every asset within that castle is wearing a suit of armor and then work your way outward, then you've taken care of making sure that you're secure and you're going to check boxes for compliance along the way.
So let's now talk about the risk and some legal risks arising from the data breach, including what are the legal liability issues to be concerned about after a breach happens, what happens if data is lost as a result of the breach, and what happens if confidential data is exposed. Dana, did you want to start off with those?
Sure. So it's interesting because if you look at the data breach cases brought to date outside of the law firm context, they have not had much traction. Plaintiffs have been suing essentially too early. They've been suing and saying there's a breach and look, my credit card was compromised. And the court will say, well, what's your damage? What's your harm? Because a lot of the times the credit card companies will reimburse them. There's no identity theft. So the majority of data breach cases have been dismissed based on plaintiffs lack constitutional standing, with the exception of the Ninth Circuit in California, which is an outlier. They haven't been successful. I have not seen any cases so far brought against law firms for data breaches, but I think they would have a lot more traction to go forward. I mean, you just think about if something happens, if we set legal and ethical obligations to our client. We're representing them. So obviously there's malpractice claims, there's negligence claims, breach of fiduciary duty, but the damages would be so easy to prove in certain circumstances. So for instance, if there's a merger that didn't go through because someone hacked into the system and leaked it, right? I mean, there's a lot of damage there. If a case had to settle or didn't go through because confidential information was leaked, if proprietary data relating to like a formula of a company was leaked. So I definitely see a lot of lawsuits in the future, although I haven't seen any. Have you seen any yet?
No. I mean, I think there would be a good claim, and then the biggest risk is you lose the client.
Right. Your reputation,
that's when I've had folks look at cybersecurity insurance, like it's not protecting me from that, and that's my biggest risk.
Right.
But yeah, I mean, if it happened, I mean that's the number one thing that would be concerned about.
Right. So from a legal liability standpoint, it's definitely a high risk that reputation. The worst that would happen is if it becomes public and your security is not good, and then that gets out. I mean, that's very bad for getting future clients. So do you want me to talk about? Notifications. So the one thing we also didn't talk about with notifications was sometimes your data is located outside of the United States. And that's a whole nother level of compliance we have to deal with because we have to look at data privacy laws in other countries and data breach notification laws in other countries. So Dan and I work at Freshfields, and this comes up all the time because the EU has separate notification laws. So that's another reason why it's important to know where your data resides. So for law firms' notifications, we would not have we'd have to work with our client to have them notify the potential data subjects that were injured. So we would not do that ourselves.
Is that another reason that it's another layer of complexity? Because if if it's the law firm data, that's one thing, but here you're also having client data, right? So you've got two levels of notification issues, right? You're notifying your client, and your client may have notification.
Correct. It depends what you have, and that's another concept in the world of privacy and data security, of data minimization. Law firms sometimes kind of save everything forever, and you get information in the litigation discovery. You have everything. There should be a process not to keep everything forever. There should be a data destruction process, and also again, I'm not a litigator, so it's a little bit different in my world. Than those of you who do work in litigation. But don't get information and data if you don't need it. I've had a client who's had an issue where they had a data security breach and they want me to analyze it. And they say, hey, I'll messenger over a CD with you with all the data. And I'm like, no, I don't want it. I said, what I want to know is how many records, what type of data fields were in there, and what states the people resident in. I don't need to see their social security numbers. I just need to see this, outline the information. So let's not create a bigger problem by making more copies of the data. So to the extent you can work with clients and not get information if you don't need it, or put it in some secure location where it can be accessed, do that as opposed to just continually getting more information and getting it stacked up in boxes and CDs and flash drives all over the place.
Okay, go ahead, Joe.
On the discovery perspective, if a corporate client suffers a data breach and there was data that was subject to a legal hold that is somehow lost, could that give rise to a spoliation sanction? And what are your thoughts on that type of issue as being a potential risk to a corporate client?
Do you guys want to?
So we're saying that the data is totally lost. It's not at the vendor. It's gone.
Yes.
I mean, I think a court would probably look at the steps that you took. I mean, there would be some sort of, if you could say you acted in good faith and here's everything that happened, we made the attempt, obviously that would be much better. But if there were, if the steps taken before that breach were not good, there probably could be a potential sanctions issue.
Right. You're going to get into the whole question of what was reasonable.
Yes.
Did you do your due diligence on the vendor that you were using? Had they had a history of it? In the world of the legal profession, you get what you pay for. So if you are, going on the cheap and you're not doing that kind of research, are you then subject to censure? I don't know if you're going to get the spoliation sanctions, because usually those are designed to punish the client more than the law firm when that happens. I mean, you may get something other than a spoliation sanction. You may get under what the new rules would be a curative measure. So they may find something. I'm not going to sanction you, but I'm going to find a way to put the other party in the same position they would have been as if the data hadn't been lost. Right? So the courts may look at it that way, and that should be playing out, after December of this year when the new rules come into play. How is that really going to happen? And that's something I don't think we know yet, but it's something that will be certainly on the horizon. So, which is a great segue into gauging the risks when using third-party e-discovery providers. It wouldn't as if Joe kind of knew that was coming and we could set all this up, right? But so questions here is, what concerns should law firms have or corporations have when outsourcing data to an e-discovery provider? Obviously, one is cost, but that's not the only one. What are some suggested best practices for dealing with third-party e-discovery providers when a breach happens? So, Dana, do you want to start there as well?
Sure. Do you want me to just talk a little bit about before you retain the third
Sure.
party? What sort of? So,
Sure.
I think the most important thing before you retain even a third party, and a lot of times it's not up to us. The client picks the vendors, but if it's up to us, is to really do the diligence that you need to do and look at the contract that you're signing with that third party. Just make sure that they're, so just to give you an example, I said make sure they have adequate security measures in place. So I just was looking at a contract, and this is what it said. It said, we warn and covenant that the securities procedures will at all times during the effective term of this agreement meet the information security standards and practices that are commonly utilized by the service providers in our industry, and in no event offer less protection than that which it affords to its own confidential information and materials. So I read that and I said, okay, I have no idea what that means, because so a lot of times it'll have this standard language where you're like, okay, so they're using the same security as they use for their own data, but it's not telling me what security they use for their data, and it's saying they use the same security as everyone else, which I don't know what that is either. So it's important to really ask the right questions. If you need to put the language in the contract, put that in. Who is going to assume liability if there is a breach? Is the vendor going to cooperate with you and help identify the data that's been compromised? And are there indemnity provisions? Does the vendor have cybersecurity insurance themselves? What's covered under that insurance? A lot of times when you look at lawsuits, they put a cap in. It's a low cap, so you want to address those as well. So that's just certain things to be looking out for when you give your data to a third party. And then if the third party tells you that there is a breach, it's no real different than, it's different because it's one step removed, but the steps that you have to take after are no different really than if the law firm's data is compromised. We have to work to ascertain what happens and eventually see if notification requirements are kicked in for the client.
Chase, what do you think? What's been your experience?
Well, speaking mostly looking at the vendor side of things, a lot of folks will sort of have a good plan and policy in place for how they manage their own infrastructure, but what you really need to think about too is that your vendors are also a threat to your environment. So it's kind of like being on an airplane. You may not be sick, but the guy 30 rows behind you may have a cough and you're all sharing the same air, so you're probably going to get it too. It's the same sort of thing where if you have a vendor that's got nasty things going on in their network and they connect to you, whether you're doing e-discovery or data sharing or something like that, very quickly you can become infected with whatever they've got going on in their network, and now you're part of that whole process as well as trying to lock down your system and respond to the breach right there. Home Depot was a perfect example of guys that were doing remote access control on an air conditioning system were the ones that had the infection, which started the whole problem. It wasn't Home Depot, it was this air conditioning company.
Yeah, and I mean, the contract, as Dana's saying, makes a big difference because you've got to do your due diligence because the contract may not give you much of a remedy. You may have a provider who is the absolute leader in the industry. They've got, service levels that are fantastic. They give you all the details and all their certifications, and they're the most trusted, party in the industry. And the contract says if all of that should break down and there's a breach, they'll credit you up to 30 days service for destroying your business. So there's a level of trust, so you have to trust but verify or don't trust but verify, because a lot of times the contractual remedy is not going to be very much. So you just really want to know what you're getting into to start with, and if you were using just some click through service online or Dropbox or something like that, I mean there's going to be next to nothing in terms of remedy if something goes wrong.
Do you guys see the need to just go through an audit or reassess those relationships on a regular basis? I mean, because usually people are good about doing it initially, but you end up in contracts with vendors, and okay, this is the third year now, and everything seems to be going along, but we're not keeping the same level of scrutiny as to what's happening to them. And as we've seen in the e-discovery industry, I'm sure it's going to be in the security industry as well, is things change in 3 years, right? Mm-hmm. You're not the leading, you may be the leading technology, when you get hired. 2.5 years later, you are not. And so do you guys see that as an area where work needs to be done on the law firm side, but also on the corporate side?
Absolutely. I mean, it should be an iterative process. If you're going more than about 6 months without vetting everybody that's connecting into your environment or touching your network at some point, then you've probably gone long enough. Even if it's just, you put them through the ringer the first time around and not a whole lot has changed, and you just want to go out and validate and verify that those same processes and things are in place, then it's worth your time and effort to do it because, for the time that you don't spend doing it, you could very easily wind up, with something very malicious taking place just simply because maybe they've been lax. They got through some audit or something like that, and then you happen to catch them at that particular time frame. Well, their next audit may not be for 5 years. So you have 5 years of degradation going on while they're keeping up with technology and growth and everything else. What are the odds that something's going to find its way in there?
Yeah, I mean, because the pace at which technology is changing is fantastic. So in terms of your vendors, your internal policies, everything, I mean, you have to revisit this on a regular basis. It makes no sense if you had a policy that says, yes, our TRS-80s are as secure as possible. If nobody's revisited the document in 20 years, it's totally worthless. So you got to make sure that you do this. And I've seen some client documents, that reference old systems. I had one client that had a public-facing privacy policy that talked about how their system worked in Netscape Navigator. It's like you got to revisit policies and look at them because you may have some references in there that make you look bad because then when there's an incident, somebody may ask to look at your policy, or there's litigation, your policies may become public. And if they see these ancient references, to Windows for Workgroups or something like that, it's going to be a real problem.
Lotus Notes.
Yeah.
Well, have you seen that a lot of the privacy policies that are out there, when you're putting privacy policies for corporations out, they're actually published, right? A lot of them have to be published under some of the breach laws, and so that now becomes easily ascertainable. That you're outdated and you need to keep them up to date.
Yeah, I mean, folks try to be technology neutral when they know something's going to be public. Internally, they may have other things that are much more specific, but they try to be technology neutral. I mean, if you're dealing with someone that's not going to have to file this document, you still need to realize that it may be viewed at some day by somebody. And again, it's not just a policy just to have a check-the-box policy. It's got to be actionable. So it should talk about your specific environment, as I said, and talk about your specific systems. But you will have to update that regularly.
So I just wanted to take time for any of you in the audience who had any questions. It's easy for us to keep talking, but if any of you guys have questions, we'd love to hear it. Chris.
I know you mentioned about doing some testing. What types of testing would you recommend for, say, your internal network and even for your actual vendors to test their cybersecurity?
Were you talking about penetration testing and other things like that folks can do?
Well, I mean, interesting, when your vendors, of course, are going to tell you what they're going to allow to go on. So they may say that, well, we don't do, black box testing or testing for our applications or red teaming or anything like that. So you may have to do sort of a check on how much risk are you willing to accept, because if that vendor says, they're not doing these tests and they still want to connect to your network and that's something you have to have, you may have to figure out a way to bring them in and then give them a segregated environment so that because they're not testing, you can at least keep them there. But for your own environments, you should be at a minimum doing pen tests pretty regularly, every 12 months, probably at a minimum. Personally, I prefer every 6 or 3. I'm a little bit security paranoid because that's what I do. And you should also be, if you're a company that's dealing with applications and technologies and things like that, you should also be doing at least 2 or 3 different tests before you actually roll that technology out and use it in any sort of live environment. I just read a paper recently that application developers that were surveyed about apps that they're rolling out for their own company's purposes, they've responded, and 96% of them said they do 0 security checks before they put that application into play. And that's because it's going out into an environment that's theirs, that should be theirs, that's tested, right? So that's their security system. So why would they worry about it? It's their environment, their application, send it out there. Yeah, pretty staggering. It's very minimal. I mean, it's just like having your house, right? If at night before you go to bed, you walk around and make sure you lock, jiggle the locks a little bit and make sure that they're locked. Same sort of thing for your network, for your environment. Have somebody testing it, red teaming, white box, black box, application testing, security environment testing, all that. And it should be on a scheduled basis so that you know when these things are going to take place.
Anybody else before we move on to the next? You. Could you just turn the microphone on, I think, right there?
Yes.
Yeah, there you go.
The larger law firms that all of you guys all come from, how often are you seeing discovery people be involved with these types of high-level IT decisions and involved in cybersecurity?
I originally started out doing e-discovery, and then it morphed into doing cybersecurity and data privacy. I think there's a lot of overlap. You're dealing with data, right, and the same issues come up. So, but I actually don't, for some reason, it's almost like it hasn't become as integrated as it should be. I think in the future it will be, but still people say, oh, I'm e-discovery, I'm this, but it really is all data. So I think it's better to really know a little bit about e-discovery, cybersecurity, and privacy. It will be much more marketable.
I would agree that those are all sort of coming together, right? We talk about them as separate pieces, right? But as we were looking at the pie graph before, it really is part of the same universe. It really is. If you want to call it information governance, if you want to use that as the framework of this is what the information is, how do you deal with it? We're all needing to become more aware of what the various pieces are, whether it's e-discovery, whether it's what you would consider information management, privacy, security, all of those things that have such an interplay now that we really do need to be, as practitioners, we need to be it. I've seen more firms trying to move in that direction. Certain firms are doing a better job than others in terms of having that together, but you really are talking about, and if I am misphrasing your question, I apologize, but it seems like you're taking the e-discovery side, the IT side, the compliance side, the privacy side, and those guys are having to come together. They may not be the same group, but they're having to get together and work together to find answers to the questions in the law firm world and in the corporate world. Question in the back?
Yes, I don't have a microphone. I'm curious if anyone has seen weaknesses or any bugs, security bugs in the e-discovery systems themselves.
Pretty sure that if we had enough time and enough Mountain Dew, we could probably find some bugs in there. I would have to go and do a little research on those particular applications themselves, but just seeing how much some of the other more, some of the really prevalent applications that people are using, everything from data science to analytics to you name it, those also have had vulnerabilities associated with them as well. So, essentially, I would say there's almost 0% chance that there's not at least some vulnerability or some bug in those applications somewhere along the way. And it's not because they didn't engineer it right or put their effort into it. It's just because that's just how things work in this space. Anybody with the right amount of time will find a way to leverage something in that application.
So do you guys see the move to send all the cloud-based applications as an additional risk area, security risk area, or is that, or strangely enough, is that more secure because of what the companies are doing to address it?
Yeah, I think that's an interesting sort of point in cloud, is that there's really two ways that people are sort of looking at cloud right now. It's either really cheap and really easy to use because it does something very simple and takes care of X, or you use it for the purposes of owning the landscape and being able to actually quantify everything that's taking place because it's your cloud. We've literally sort of flip-flopped on that, of going from, in the past, where you used to set up a network and you own that network, and then you start bolting all this other stuff onto it. That was the problem. Now in cloud, what we have is you either have really cheap, really easy, you can store stuff, spin stuff up, process stuff at eon speed or whatever, or you can go and you can say, we own this space, we're going to lock this down because anything that we put in this space is ours, and we control it from the moment that it starts breathing until the moment that it dies. So it's one or the other, really. We haven't seen anybody in the middle. They either say, well, we really care about this and we really want to use this model, or we'll just sort of take our chances and think we've done our job right and throw it out here, because we need really, really cheap computing and that type of thing.
All right, well, let's go to the next topic here, which is best practices for reducing risks associated with hacking incidents. So here what we've got are there industry standard best practices for reducing the risk of liability? What can be done to limit the scope of a data breach? And what are some resources that are available to law firms and corporate legal departments that can be helpful? So Gary, why don't we start with you in terms of the best practices?
Sure, and there are different standards and laws that you can look at. Whether you're going to go through an ISO framework, or if you were in the medical industry, HIPAA has certain standards. One of our slides, which will be available to you, talks about a Massachusetts security law, which lists 12 different controls that companies should have in place. So there are different standards you can look at, and if you dig into this area, you'll hear the refrain, which I've said a couple of times, that the controls and processes only make sense based on the size and scope and complexity of your organization. So you need to find something that works properly for you. In terms of reducing the potential damage from a breach, going back to that information security policy, we talked about taking sort of the inventory of your data and information. It's getting control about how much data you have and where it's located and who has access to it. A lot of times when there's a breach and we start to analyze it, we start to realize that one of the problems that caused the breach is that somebody had access to information they should not have had access to. Chris mentioned sort of losing the laptop in the airport or leaving it in the back of the taxis. A lot of times when I've had those breaches, it's like, all right, they've lost their laptop. But then we find out, the HR person had the entire database of all the employees and their social security numbers on their laptop. Well, they weren't supposed to have that information on their laptop. That was supposed to stay on the corporate network. So in terms of mitigating and reducing the chance that you're going to have a breach, is making sure the internal controls are in place so that you don't have everybody having access to everything on every different device, because that's definitely not needed. And it frustrates people. Chris mentioned, some people don't like two-factor authentication. You don't like, to have an extra, login because your laptop's been encrypted. But, these controls are important.
Chase, did you want to talk about some tips for reducing risks?
I sort of already mentioned about figuring out, the 1 or 2, maybe 3% of your network that is that real critical asset, the formula for Coca-Cola, if you will. Put that in a vault. Again, bad guys and folks that are actually going to cause harm and detriment to a network, they're not after your mail servers to some degree. They're not after your entire infrastructure. They want that critical piece of data. Figure out what that is, and then put that somewhere where it's bulletproofed. And then you've solved that problem. Even if somebody gets in, great, they're in there. What are they going to get? Big deal. They're there, you find them, you isolate them, remove them, get them gone. Isolation absolutely is the key to security, if in my opinion, in my experience. The more isolated things are, the more We built IT now. We built systems to be really flexible, really usable, which is great. But if you don't want everybody out there using everything like he just talked about, lock it down. There's no reason for you to have access to it. Don't have access to it. Very, very simple. If you don't really understand the threat, find somebody that does, because that's a real common problem. Folks are worried about hacktivism, or they're worried about denial of service. That may not be the problem for you. You need to understand what the real threat is for yourself, and that's how you apply the controls to it. Why bother spending money on a $2 million alert system when you don't need it? Go spend it on stuff that's actually going to work for you and takes care of your problem. And then the last thing I would say is, outrun the bear. I don't have to outrun the bear. I just got to outrun the other guy, right? So if you're a hard target, the bad guys will go find someone else. And it may not be necessarily the end-all solution, but in the world of who's going to win, I would rather have them go find someone else to attack than me. And if you give them a hard target, they will get fed up and they will go find something else. Because from a hacker's perspective, if I can get 10,000 credit cards or a million, data records from this company, and I can't get 50 from you, why would I even bother with you? I'm wasting my time. I'm going to move on. It's literally time and revenue for them. They make a lot of money on that stuff. If you're a hard target, they'll find someone else because there's a billion of them out there.
So what are some resources, I guess? One, right? We talked about it before, but that's the IAPP. Did you guys want to talk about that?
Yeah, so I'm very involved in the IAPP, which is the International Association of Privacy Professionals, and that's and Dana's involved as well. It's an organization that addresses privacy and data security for all industries, and it's not just lawyers. It's lawyers, chief privacy officers, compliance people, technology folks, and it's actually massive now. I mean, they have their own certification. And they now have over 15,000 people, I think, who are certified, or 18,000 people who have gotten certified in this privacy certification. And it addresses every industry. It addresses, healthcare, financial services, government, advertising, everything you can think of. But there's a lot of learning. So, you can go to their website, it's privacyassociation.org, and start to read. And you'll see a lot of the things we're talking about standards, reasonable security, responses, policies, and start to become attuned with the language of this industry.
It's interesting because I had never gone to the conference before, and it was insane. I mean, really, there were so many people there, and apparently it used to be like a room like this, and because the area has become so popular, so there'd be like 10 sessions going on at once, and there were lines like out the door. You couldn't get in; you'd have to wait for someone to come out. So. Yes, it's definitely the organization to be involved with.
And they'll have white papers. They'll have things that you can sort of find to help educate yourself as you go through it. I find myself turning to it whenever questions come up. Well, what else is out there? Checklists, certain other things that people. And there's a knowledge net, so you'll actually you'll get emails. Someone says, well, what about this? So you'll see something that says, well, what about the new policy in Russia that's going to require all of the data to be housed in Russia? And then there'll be responses, right? So they're, as a general piece, they're more open and sharing than most other organizations. They'll be free. And I've actually emailed somebody offline after one of those posts and say, well, did you look at this, or how does this happen? And you end up having a conversation. So from my own practice, it can be helpful. So I would expect you guys would agree. Yeah,
and it's very good. When you have these large privacy conferences, it's great to tell people, I'm going to a large privacy conference, and they say where it is. You say, I can't tell you that.
All right, so now on to the second to last topic here. Meeting client demands for increased data security. We've touched on this a little bit earlier about what clients are requiring law firms to do in order to meet their own requirements, and are there issues of concern that law firms plan to address regarding those increased demands? So Dana, did you want to start with that one?
Yeah, I think we talked a lot about things that clients are looking for. There's detailed questionnaires again on how we house data, retention policies, preservation policies. So clients are asking detailed questions. Are we ISO certified? The other thing that's become new that I think it's existed in the financial services industry, but not so much in the law firm world, is information sharing. So usually the same hackers are going after the same industry, the same data. So there's a bunch of law firms that got together, a lot of AmLaw 100, like Sullivan, Debevoise, Paul Weiss, and they are basically formed this alliance where they're going to share information about hackers. So that, I think, will become much more popular, and that's a good way to be alert for that. And then, yeah, so I think all the other things we talked about, unless you have anything else to add on.
No, I think saying kind of be prepared, because
Yeah.
we talked about those client questionnaires. When those client questionnaires come in, that you don't want that to be the first time you have had to answer those questions. You want to have done the analysis yourself internally, so then you're able to quickly respond to the clients.
One of the things we had listed here is invest in logging and event correlation. Did you guys want to talk about what that is and how that can help?
Yeah, so if you have a really good logging event correlation system, like for us at Firehost, we average anywhere from 25 to 30 million security events per day. We're averaging a few billion per week that are trying to get into our network. And because we've done a really good job at investing in the right sort of tools and techniques and technologies to get after that, we can tell you individually down to the machine, which machine has been targeted by which asset and how that was affected and things along those lines. There are systems out there and tools out there which allow you to get through those volumes of data specifically around logging to know what's going on. Because if you're not logging that stuff, then you don't know what's actually taking place. And if you log it, that's great, and there's lots of requirements out there that do have you log it, but then you have to actually look at it. And when you really look at the stuff that's going on that's of importance, you will see a huge increase in what you really need to pay attention to. So being able to correlate specific activities to specific threats and specific vectors, that's where you get security and protection from. You have to sort of turn your eye to that and really pay attention to it. And again, it's just like in the specialty area where if you're not really well versed at it, you kind of won't know what to look for. So you may have to consult outside folks to get them to help you figure out what to go after, or maybe help you figure out which piece of technology to put in place for that.
How about just when you're handling client data? I mean, that's if you're subject to a breach, you're subject to an event. But even on a general level, Gary, what have you seen in terms of people with handling their client data? Are you finding that clients are requiring encryption? Are law firms now doing stronger encryption, having multi-factor authentication?
Mm-hmm. I mean, clients are asking the question because not every law firm is going to be the same, and the type of data they have is not going to have the same risk. We talked a lot about these questionnaires, and it's because it's not a yes or no answer. Do you have good security or not? It's what do you do, and then I will piece that together, and I'll have a picture of your controls, and then I'll make a determination: are these controls reasonable for what I have? So, I mean, that's what it is. Clients really wanting to know what you've made the determination to do internally to put together a good picture. And it's going to be different, from company to company. Again, the multinational firm versus the single office firm, someone in the United States versus someone outside the United States. So it's just, having the appropriate answers about what controls are in place.
Okay. I know I've seen clients, more clients now sending data encrypted. Mm-hmm. Right, so you as the law firm are receiving encrypted data. You as the law firm are sending encrypted data. So I would say that certainly in my own practice I've seen that. But I also see that firms are probably responding to those questionnaires going, okay, if I'm not getting this business, and trying to figure out why, they're going to be saying, okay, well, I need to do X, Y, and Z to put myself in a position to be able to get that business. Have you guys see that as well?
I mean, it's like part of like a pitch process for...
Yeah, whether it's a pitch process or whether it's sort of the post-mortem after you don't get the business, trying to figure out what can I do differently.
Yeah.
And I see the security aspect of it sort of making a big role, right? Because if you can identify that that's a reason why you're not getting selected or you're not being able to meet those requirements, then you're considering, well, what do I need to do in order to satisfy them?
Yeah, I mean, I would say that's in any industry, today
yes.
when it comes to security.
Yes.
That you look at a party and they may look at their security and say you're not at a level that can work with me because you don't have the appropriate controls in place. So that applies to a law firm, to any type of vendor, that you may look at them and say, you're not capable of working with the type of data that we might give you.
Well, I think when you talk encryption, that there's something I haven't seen the questionnaires, but it should be on the questionnaires. Do you encrypt data both at rest and in transit? Because a lot of times people will take the time to encrypt data at one point or the other, but they don't do both, and then you basically have nullified the whole point of encrypting it anyway, because if somebody gets either inside of that transit route or on that endpoint, your encryption's useless. So that's a question that I would sort of pose, just like, if we're going to do encryption, let's do it right and make sure that we do it both at rest and in transit.
Okay. So there was a recent article, right, Joe, on this that came out, I guess it was yesterday, right, on 12 issues that threaten information security and data governance. That was in Law and Technology News, which I can tell you is one of the things that just pops up on my email all the time. But there are 12 key items to address, right? And we can run through them, but we've hit on a lot of them. Mm-hmm. You know, what are your email practices? I mean, email practices are not just, hey, is that a stupid email to send? But it's, how are we keeping emails? What are we doing with emails? You know, how are we setting up file shares and as it says, unapproved repositories? I mean, are you guys seeing that? That the client says, okay, let's set up a file share, right? Let's use FTP. Let's set up a file share. What are you guys seeing on that? I mean, is it just something that you're going to stop, say, wait, stop, think about that before you do that? Or is it just they're becoming more attuned to that to begin with?
Yeah, I mean, I think people ask about the system you're going to use, you know, and again, I don't mean to, you know, badmouth any different systems. I mentioned, like, you know, Dropbox, because it's a very, you know, popular consumer, you know, application, but, you know, is this going to be appropriate for business purposes? You have to analyze that. And so I think everyone starts looking at these file sharing services and, you know, and realize, is this appropriate for, you know, for a litigation to use that for sharing documents or not? And you got to make that analysis.
Mm-hmm. Some of the other things there are obviously removable media, password policies, ongoing rights management, asset disposition. I mean, that's probably one of the more interesting ones is, what do you do at the end of life of your computer, right? So we all know that we can do forensic investigations on computers and carve and go into Slack space, but as a law firm, are you addressing that issue when they dispose of your assets? For example, when your computer is up and you have to give it back, it's on a lease and you have to give it back. What are we doing to that information before we return the computer?
There are standards you can meet. There's you know Department of Defense standards for wiping drives. There are physical hard drive shredders, but now that everything is in RAM,
RAM, right?
Yeah, you got to look at the control to get rid of it.
Okay. So in conclusion, this is based on the recorder here, clients, law firms, as the Security Week link. They're seeing 77% of corporate survey respondents last year stated they have security requirements for third-party service providers. But only 52% said those requirements extend to their outside counsel law firms. Right? So again, it's getting to the point of what you're saying. It's the same. It's following on the whole encryption piece, right? Which is, if it's at rest, is it in transit? If you're requiring your other vendors to have that standard, shouldn't you be asking your outside counsel law firm to have the same one? And then how do we figure out what's the right one for which law firm? Should we have the same standard for the 4-person law firm that we have for the 1,500-person law firm, where the data is different? And should that standard differ by the type of company that you are, right? The type of data you're talking about? And so I'd open that up for you guys, but that's certainly something we've talked about. But it's going to be an ongoing question, right? There's no easy answer, I guess, is the point.
Right. I mean, the hard part is there's no standard, as we all said. I mean, if you leave your door unlocked, that's not secure, right? And if someone steals your papers, that's easy. But when someone hacks in your computer, there's no, and it's not just in the legal industry; it's everywhere. We don't know what a reasonable measure to take on it. So hopefully we'll get more guidance, and then we could work from there.
So that's us, right? These guys. And then you've got some contact information for ACEDS. But really, and some additional reference materials. But again, I'd like to open it up for questions, because a lot of the learning that goes on in sessions like this comes from the questions that you as the audience ask. because although we have our own questions, sometimes you guys are looking at things a little bit differently. So does anybody else have another question? Sure, Chris.
I know you mentioned that the federal government is making its way towards a federal law. Any idea as to how close they may be, or are they still light years away?
Well, I'd say you are talking about the federal government. So, we have difficulty, having anything come out of the federal government. But I'll open it up to these guys.
Yeah, I mean, but there are some things, our Congress can be very dysfunctional about getting things done. But, privacy and data security issues tend to be somewhat, bipartisan, that everyone agrees, yes, it's important to have good security in the country. And it's kind of the low-hanging fruit of having a federal security breach notification law, because, again, there's 47 already. Let's have one on the federal level, just make it consistent. That seems to be easy versus other laws which require certain industry sectors to do particular things, which is more controversial. So I think it is possible that a law will come about. It'll be interesting. The big thing will be, how do they define personal information and who it applies to and what sort of carve-outs there are. I mean, if any of you remember, the Federal Trade Commission put in place the red flags rules to require notification about anything that might, have a risk of identity theft. And the American Bar Association lobbied very hard, saying this does not apply to law firms. And it actually sued the Federal Trade Commission to make sure that it would not apply to law firms. So it'll be interesting to see how the law comes about and who it applies to and what data it covers.
But do you guys see, and I'll jump in, but do you guys see a sort of closer sort of overarching or an overarching law that would sort of encompass that with the CFAA and the Stored Communications Act? I mean, there's so many pieces out there, but there isn't sort of something that brings them all together. Because, with the CFAA, or the Computer Fraud and Abuse Act, the employee who has authorization to access that data and then uses it somewhere else is not necessarily violating the CFAA. So you've got these loopholes in various laws that people can exploit. Do you guys see those being part of this effort, or would we really just be talking about a federal breach notification act? Law.
Now you've gone from low-hanging fruit to the
correct.
fruit, 10,000 feet up in the sky. So
right.
It would be great to, have that fixed, and it does need to be fixed, but that's going to take a lot more work.
And actually, the Obama discussion draft, it carved out, it said it defined personal data and carved out, I think, Graham Leach Bliley, it carved out certain laws, so it didn't preempt everything.
Yes, sir.
For the 3 states that don't have a data privacy law, I mean, is there anything you have to do, or is it just wild, wild west that you don't have to tell them anything?
Well, the reality is, if you have a breach, and you're going to notify everybody. I've seen very few corporations and companies that will look at it and say, all right, I've got to notify everyone in these 47 states, but now I'm not going to send any notices to my customers in Alabama and New Mexico and South Dakota. I mean, they're going to send a notice to them as well. There's no standard in terms of what they're supposed to do, but if they have a nationwide breach, they're going to notify everybody. If it was a very localized breach, it was a company located in one of those 3 states, yeah, they may look at it and say, I don't have an obligation in this state to tell anybody, so why would I? But if it's a national breach, everyone tends to include everybody.
One of the other things to think about there is a number of the state laws actually require notification to their citizens if their citizens' data was breached, even if they're living somewhere else. So you've got Massachusetts pursuing actions against hospitals in Rhode Island and elsewhere, and so this sort of patchwork quilt actually goes way beyond the state borders, which is an issue. It's kind of funny in a strange way that we're allowing states to implement laws that go so far beyond their own boundaries as to impose regulations on companies that may or may not do any business in the state itself, but they are providing services to residents of the other state. So it's just something that is going to be sort of moving around. So those 3. The point of my statement is not to confuse everyone, but to say for those 3 states, companies operating there already have obligations. So they may very well just decide to, provide notifications. And if you're the company looking for it, a lot of times what you're looking for is what's the highest one, right? It's not the lowest common denominator, it's the highest one. What is the highest standard that I need to comply with to be safe? And so you're going to try to figure out what that is, and whether that's Massachusetts or Nevada or California or some combination of all of them, you're looking at that from a privacy standpoint, right? But we're also, we tend to sort of conflate the two, but they are also, you're talking about a data breach, talking about personal information, but the information that's being obtained in a data breach is not just the personal information, right? It's a lot of the proprietary information. It's a lot of the things that are critical to your business that may not constitute personal information. So, anybody else? Can we, did we put everybody to sleep? Is everybody doing all right? Well, one question in the back. We got one.
So when it comes down to like data destruction stuff, let's say that you did change your infrastructure, or your IT team did change your infrastructure, and your discovery manager is trying to get into it, and you're going into data destruction. How do you feel? How long is too long to hold that?
So you're saying in terms of data destruction, right? How long is too long to hold on to it? How would you change your infrastructure to address it?
No, you already changed your infrastructure, and now you're getting ready to destroy this data that you have from the change.
Okay.
How long is too long to hold on to?
Okay.
Forever is too long. That I will say. It's the strange thing that clients have data destruction policies, and sometimes they're very strict. They may clear out the inbox automatically within 90 days, and they only save documents. They have document retention policies. Some are 2, 3, 7 years at max, but somehow they expect their law firm to keep everything forever. And it's not reasonable. So a law firm's got to have a destruction policy as well. I mean, you just cannot keep everything forever. Obviously, there's the cost, which would be prohibitive, and there's the risk in case someone breaks into it. But you got to find what's reasonable that your clients expect, and maybe notify your clients about what your destruction policy will be. But in terms of what's the exact number that works for that particular company, again, it's somewhere between forever and 1 day. You got to find the right spot. There's no industry standard for law firms that I know of about how long you would keep it.
No, other than you have the general sort of sense as the lawyer that, of course, you want to keep it forever because you might need it for something else, right? And something else might come up and I want to have it. So that's the sort of pack rat mentality that, that law firms generally have.
And for existing representations, we have ethical obligations to retain data. I forget what the rule said because I just read a discovery case where that was deleted. But yes, we do have certain ethical obligations for existing clients.
Well, thank you for sitting with rapt attention. Hopefully we were able to assist.
Definitely did not put us to sleep. Thank you, Dana. Thank you, Gary. Thank you, Chase.
Thanks, guys.
Thank you, Chris. Thank you, the panelists. Thank you, Chris. Great job, everyone. And I'm sure we'll be hearing